Welcome to this training tutorial on the protection of databases and digital preservation, created by Barbara Colony-Reiser and Elena Marks, and brought to you by the Timbus Project. This training video, broken into 2 segments, will provide guidance on the protection of databases and the permissions needed to ensure the legal digital preservation of databases. In order to digitally preserve business processes, an organization will more than likely need to preserve one or more databases. If this is the case, the organization may need permission from the author of the database or the database maker, who is the exclusive rights holder to the database. Digitally preserving databases requires acts of reproduction, adaptation, and alteration to ensure future usability. However, these rights to reproduction, adaptation, and alteration belong to the database maker. As the database is protected sui generis, the database maker holds these rights as protection for the investment and risk they have taken to build the database. As a consequence, if an organization wants to digitally preserve a database, it must secure permission from the rights holder to avoid infringing their exclusive rights. Whenever performing digital preservation of third-party material, such as databases, an organization must determine whether the preserved objects are protected and what rights might be infringed during the performance of digital preservation. 2 types of protection could apply, depending on the nature of the database. Some databases are protected by Article 3.1 of the Database Directive. This article states that if a database meets the defined criteria, it will be protected by copyright. Some databases are covered by Article 7 of the Directive through sui generis protection. A database can enjoy protection under both articles. They are not mutually exclusive protections. Neither, however, does one type of protection necessitate the other. A database can be protected by one or both articles, or not at all. What constitutes a database? Article 1.2 of the Database Directive defines a database as a collection of independent works, data, or other materials arranged in a systematic or methodical way and individually accessible by electronic or other means. The directive deliberately abstains from requiring a specific form. As a result, the directive applies to a broad variety of databases: electronic or non-electronic, dynamic or static, printed or digital. When is a database protected by copyright? A database is protected by copyright when it meets the requirements defined in Article 3 of the Database Directive. If the selection and/or arrangement of the content of the database derives from the author's own intellectual creation, clearly extending beyond the underlying concept, then a database is protected by copyright. No aesthetic or qualitative criteria need be fulfilled, only the original selection or arrangement of the author of the database. The protection of a database does not extend to the content within the database. A database and its content enjoy separate copyright status and is not interdependent. As a consequence, content that is not autonomously protected by copyright does not gain copyright protection by being included in a database that is protected by copyright. Similarly, a database that is not protected by copyright does not gain copyright protection by containing content that is protected. In order to receive permission for the necessary rights to digitally preserve a database, the rights holder must be identified. Often, the rights holder will be the author of the database. The author of the database is defined in Article 4.1 of the Database Directive as the natural person or group of natural persons who created the database, or, where the legislation of the member states so permits, the legal person designated as the rights holder by that legislation. In other words, a natural or legal person can be the author. The issue of who holds exclusive rights to a database created by an employee during the execution of their duties has not been harmonized by the Database Directive. the definition of authorship remains dependent on national legislation. For example, in Germany, the employee is considered to be the author. However, in the United Kingdom, authorship belongs to the employer. What exclusive rights belong to the author? Article 5 of the Database Directive defines the rights enjoyed by the author of a database. Exclusive rights of the author include reproduction, adaptation, and alteration. However, digital preservation requires all of these acts. To begin with, an organization must gain permission for reproduction. The right of reproduction is one of the most important permissions required for the digital preservation of a database. In Article 5, reproduction means temporary or permanent reproduction by any means and in any form, in whole or in part. Because this is such an extensive formulation, an organization must gain permission to print or copy the database. This applies even to downloading electronic databases into a computer's RAM, as this is a form of temporary reproduction. Resultingly, in order to store a copy of a database during the digital preservation of business processes, an organization must gain permission from the author. In addition, an organization must gain permission for adaptation and alteration because these acts are required to perform migration. Migration refers to the process of moving a software system from its original environment to a new environment. Some exceptions do exist for exclusive database rights. In Article 6.1 of the Database Directive, these exceptions are defined. The performance of the lawful user which is necessary for the purpose of access to the contents of the databases and normal use of the contents shall not require the authorization of the author. Based on this exception, Article 6.1 defines minimum rights that cannot be waived. Lawful user is the person who uses the database with the consent of the rights holder. Usually, consent to use the database is established in a contract. Normal use of the database means, for instance, browsing the database. More exceptions exist within some national legislation as well, as established in Article 6.2 of the Database Directive. For example, some national legislation provides exceptions for teaching, scientific research, public security, and administrative or judicial procedures. However, no national or EU legislation provides for the exception of making a backup copy to prevent data loss during the performance of digital preservation. What does sui generis protection entail? An author's own intellectual creation is covered by copyright protection. Sui generis covers databases for different reasons. According to Article 7.1, to enjoy sui generis protection, the maker of the database must have a qualitatively and/or quantitatively substantial investment in either the obtaining, verification, or presentation of the contents. The important criteria to note in this type of protection is the substantial investment made in the composition of the database. The content is not protected under sui generis either. Since substantial investment is the requirement for sui generis, how is substantial investment determined? In this context, investment refers to the use of resources necessary to create a database. According to Recital 7 of the Database Directive, the composition of a database requires an investment of considerable human, technical, and financial resources. Recital 40 further qualifies this requirement to include expending time, effort, and energy. For example, acquiring systems to relocate stored information, such as a thesaurus or index, amount to a substantial investment. A more specific definition of the term, substantial investment, however, does not exist, leaving some ambiguity in the law. This is the end of Part 1 of Database Protection and Digital Preservation. To hear the second part of this training tutorial, please watch the video for Part 2.